Hello friends, in the series on the income tax cases, today we will discuss a very important case which is based on the limitation period for imposing the penalties under section 275 subsection 1 clause C. Section 275 subsection 1 clause C, which was appearing as for the assessment year 12-13, says that the penalty can be imposed within the financial year in which the proceedings are completed or within 6 months from the end of the month in which the penalty proceedings are initiated, whichever is later. The dispute arises that what should be the date for the initiation of penalty proceedings, whether it is the date on which the AO refers the matter to his additional commissioner for the penalty or the date on which the show cause notice for imposing the penalty to the assessee is issued. This critical issue has been taken up by the Honorable Karnataka High Court in the case of Principal Commissioner of Income Tax and another versus K. Umesh Shetty, and this case is reported in 479 ITR at page number 270, and the date of the judgment is 17th January 2025. The present case relates to the assessment year 12-13. In the present case, the assessment order under section 143 subsection 3 was passed on 26th February 2015. The learned assessing officer on 16th November 2016 referred the matter to his additional commissioner for levying the penalty under section 271D on 16th November 2016. But the additional commissioner issued the notice to the assessee for imposing the penalty after more or less 1 year, that is on 10th November 2017. And after that, after the submissions of the assessee, the penalty order was passed on 22nd February 2018. When the assessee was contesting this matter with the CIT appeal, it was the submission of the assessee that this penalty order is time barred. Since the penalty was initiated on 16th November 2016, so if 6 months are calculated from the end of the month, that is November 2016, and since the penalty order is passed in 2018, so the penalty order is passed well beyond the limitation period, so the penalty should be deleted in the case of the assessee. But the CIT appeal didn't entertain the appeal of the assessee, so the matter was before the tribunal. When the tribunal heard the matter on the issue of limitation period, the tribunal first of all said that there is no limitation period is prescribed as far as the initiation of penalty proceedings are concerned. But at the same time, the tribunal was of the view that the initiation of penalty proceedings should be taken from the date when the assessing officer referred the matter to the additional commissioner for initiating the penalty or for show causing the assessee for the penalty. But the revenue was contending that the limitation period should be started from the date the show cause notice was issued to the assessee. For this, the tribunal said that there is a lot of difference between the initiation and imposition of penalty. The initiation of penalty comes earlier than imposition of penalty, and limitation law is not a mere matter of some technicality, and there is no provision in the Income Tax Act for extending the limitation period for imposing the penalties. Since in the present case the assessing officer has referred the matter to the additional commissioner in November 2016, so if 6 months are calculated from the end of the November 2016, the penalty should have been issued up to 31st May 2017. But in the present case, the revenue is calculated the 6 months from the date when the additional commissioner show caused the assessee, that is on November 2017. So The tribunal said that in the present case, the penalty is time barred, which was upheld by the Honorable Karnataka High Court. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax and another versus K. Umesh Shetty. And this case is reported in 479 ITR at page number 270. And the date of the judgment is 17th January 2025. Thank you, friends.